Hello and welcome to the New Books Network. I'm Pierre. Art and the law have had a long history together. Not only has art been a domain to which the law can be applied with a variety of intriguing outcomes, but various forms of art have long been intertwined with forms of the law itself. Classical literature and theatre, for example, have found ways to form, interpret, or mediate the legal system that developed concurrently with them. Similarly, art has been an agent of cause for justice, not least in the turmoil of recent years. Aristotle already noted the ways in which art can support the desires for catharsis, at the very least. Today, art activism, for example, is an established genre with its own literatures and institutions. But we shouldn't assume that the relationships between the law, justice, and art are synonymous and benign. Indeed, art's calls for justice throughout history has been a source of discontentment. In the words of my guest today, art can be annoying. Art is very well suited to deal with this annoyance or to provoke it. My guest is Frans-Willem Korsten, and his new book is Art as an Interface of Law and Justice: Affirmation, Disturbance, Disruption. The book looks at a range of examples of art as a force that mediates between the structures of the law and the desires for justice. Frans-Willem Korsten holds the chair of Literature and Society at the Erasmus School of Philosophy and works at the Leiden University Centre for the Arts and Society in the Netherlands. I'm very happy that he joins me now to discuss his book and his research. Frans-Willem, welcome to the show.
Thank you, Pierre, and thank you for inviting me.
Well, it's a pleasure. I've had both a lot of fun and quite a lot of headaches with your book, which is maybe a test to my limitations, but also to some of the complexities of the material and some of the detail with which you contend. But before we get into any of this, I want to ask you a couple of easy introductory questions. So first of all, if you could tell us maybe a little bit about your research trajectory and how you came to engage with the legal process with ideas of justice and the law, and how art comes into it.
So I started out actually as a literary scholar, but my PhD research was about, let's say, the interaction between arguments and narratives. So in a sense, let's say the study of literature since the 70s, 80s has been traveling through different disciplines with certain concepts traveling, like narrative. And then I looked at popular or popularizing texts in terms of sociology or sciences. And that started out actually as a study of narratives. And then I thought, wait a minute, something else is going on. There's this constant interaction between narratives and arguments going on. So that was the start. So I started out as, let's say, someone interested in the impact that texts have and the rhetorical strategies that they employ to reach that effect, which is, let's say, always intrinsically related then to political issues, right? So let's say rhetoric is intrinsically political. Then I got a job in Leiden, and actually at the beginning I was more kind of like all of us who enter the academy, kind of busy with teaching. But then I thought at some point, some course that I was teaching was not really kind of connecting to the students. So somehow something was wrong. And the thing that was wrong that this course was developed in the 70s, 80s, which were highly theoretical. And I had classes, big classes of 250 students who didn't seem to know much literature. So in a sense, that theory was abstract. It didn't land. And that's when I made, I started out on a project that can be defined as a matter of hubris. It wanted to introduce students both to historical periods and to forms of literature and to theoretical approaches and to analysis. But the way in which I did that was that each chapter was focusing on one concept. For instance, interest in relation to enlightenment. So there was a simplicity to it, or a thing that kept it together. But writing this book also helped me to see, let's say, long lines in European history especially. And I'm not saying that Europe is, let's say, the center of universalist enlightenment, not at all. I mean, Europe has been a migrating force field for thousands of years. Actually, the 19th century nation state is an anomaly. And then one of the most intriguing things was the Baroque and the idea of sovereignty. And actually, I took by and large the most famous Dutch playwright and poet of that time, Vondel. Not very well known internationally, but in the Netherlands always compared with Shakespeare, and I think there's good reason to do that. And I noticed something that was going on in his text that was constantly struggling with the concept of sovereignty as supreme power, both politically and in its connection to, let's say, some sort of divine underpinning of that supreme power, which will later translate itself to the state. And the most important philosopher in that context was Spinoza, whom didn't perhaps know this playwright, Vondel, but they were in the same circles. And Amsterdam at the time was a pretty revolutionary place in terms of ideas. And then I followed Spinoza again to modern thinkers like Antonio Negri or Gilles Deleuze. So I started to see that line between what the Baroque did in terms of being a pivot to modernity and Spinoza being a pivot to many material philosophies that followed from that. So that was a major theme, and that ended up in a couple of books. And the last one was a Dutch Republican Baroque, where I asked the question, how can we think about the Baroque in a Republican way? Because the Baroque has always been conceived of as, let's say, related to either papal power, the Roman Catholic Church, royal power, let's say Louis XIV, or princely power, Germany. And I noticed something in that very strange political constellation called the Dutch Republic, that there was something as a Dutch Republican Baroque, which to me seemed to hold a revolutionary potential. Being very much aware of the fact that the Dutch Republic turned into a global empire. And that's precisely one of the themes of that book. So one of the painful points is that they start out liberating themselves, reflecting on the issue of slavery, political slavery, and then, not because anyone kind of envisioned that or wanted that, but they turn into a global power. And they start to engage in slave trade, right? So it's this kind of schizophrenia or paradox, which I think is more systemic in the development of modernity. But anyway, that was the last book about that one. My thinking on sovereignty and the political and legal implications of this then brought me at some point to thinking about, so how does I relate to that complex field of both law and justice, which are two things that are often equated or confused, and that I like to kind of keep a sharp distinction between. So that's where actually the work on this book started, which I developed by and large again in teaching. I like to work on books more in teaching than in giving lectures. Also because in terms of teaching, at least the way in which I do it, it's more a collaborative thing, and teaching allowed me actually to think through things with all these smart students. And that ended up in this book where I consider art to be an interface between what I call the system of law and the realm of justice.
Oh, it's fascinating. I mean, there's definitely a sense in the book in which we're being taken along your thought process, and that's even the chapter structure reveals that. But let's get right into it. Right from the cover, we have the distinction between law and justice, and I guess to an extent, this maybe mirrors the kind of question that every law student is asked in the first week. Like, is law underpinned by an ethical and moral code? Is there some kind of straightforward relationship? You waste no time in saying absolutely not. So maybe we could start by making this division clear for our listeners before we start arguing why these things might have to be problematized even further.
Yeah. I like sharp definitions. So let's say I can agree with people who say, yeah, but everything is political. Yeah, of course it is. But if you say that then what does the political mean, right? So I like kind of squeezing things into, let's say, a sharp definition to be able to work with it. As you phrase the question, the question is always immediately implying that there is such a relation between law and justice. And then again, let's say, for our listeners, I consider law to be, let's say, a legal issue in terms of laws, indeed, in a system and a judiciary and so forth. And justice, I consider to be all these different ideas of what people think to be just. Now, I mean, it would be stupid, also historically speaking, to deny that there is a connection between the two. But what's the connection? That's the pivot. And either you say there's no connection, because there have been systems of law that have been very unjust, and they were functioning, and they were functioning very well. Then, of course, the nasty part always is that apparently in this system, some people consider this to be just. So let's say the icon or the paradigm is Nazi Germany, fully functional legal system and unjust. Yes, but at that time, a lot of Germans didn't think it was unjust. So there as well, even let's say that system of law was somehow supported by people that felt that this was a just system. Still, there is reason to say there is no intrinsic connection between the two, because what people feel to be just can differ immensely. Let's say what we've been witnessing in the United States in the last 5 decades or so, this, in my eyes, abysmal or perverted growing of inequality. Apparently, there's loads of people who think that is just. So in the realm of justice, there's immense diversity in what people feel to be just. There's also some basic, let's say, common aspects, by the way, but there's also enormous diversity. So that alone in itself would be reason enough to say there can't be a direct connection between the realm of justice and the system of law, because the realm of justice is so dispersed, is so diverse, is so disparate in a sense. So this is why I started to think through, wait a minute, perhaps, let's say the two possibilities, either saying the two are radically separate or should be considered conceptually separately, or say one is framing the other, because it's always the case that people then say that the ethical is framing the legal system, right? So that the legal system should have to listen to these ethical imperatives. And what I'm saying is these are two different things, and they need an interface. And perhaps they need more interfaces than one, but one is art. That's the thesis of this study.
Well, let's try to maybe start with an example. One of the things that comes up early in the book is the case of the MH17 flight that was shot down over Ukraine. The fight and the ongoing demands by the families of the victims for justice, and this is I'm always using the word justice now in inverted quotations for now, because this needs to be quite filled out. Is something that's subject to quite complex legal processes. It's subject to some kind of sociological reactions, both within the European community, within Russia, bizarrely, which you touch upon. But there's also a realm in which art, memorialization, artistic tributes, and so on and so on, play a part. And maybe you could use this to speak about some of the terms that you have on your cover, and also within the first pages of the book, which I was incredibly amused by, but also, impressed by. You characterize calls for justice as fundamentally annoying. So maybe you could speak a little bit about how you see in very broad outline the possibilities of art placing itself in between demands for justice, what demands for justice are, and what law may or may not do in response to such demands.
Right. Yeah, Pierre, I think historically speaking, I'm just being a reporter in a sense. So most calls for justice are annoying. They are, and they've proven to be annoying. So just go to the 19th century. If people start to demand that they want more social equality, that's annoying if you have a lot of money. And even the people fighting for this were annoyed when they went on strike, and there were people trying to disturb that strike or wanted to keep on working and so forth. So struggles for justice are extremely annoying to all parties. This is also why they are tiring. And I think it's wise to acknowledge this, that it's annoying. And that it might even lead, and this was a kind of a hint given to me by Peter Goodrich, a legal scholar in this field of literature and law, who witnessed, let's say, working with legal scholars, that they were bored. So there's also this link with annoyance and ennui, French ennui. So I'm bored by these people constantly asking that they want their rights and so forth, right? So this is all true, effectively speaking. Now, in let's say this case of this flight that was shut down, if you ask me, let's say off the record, I'm pretty sure who's done this, and I'm pretty annoyed by it and hurt. I think one of the fascinating aspects, if you can call it fascinating, to this case was that loads of Dutch people were somehow connected to someone who had died there. And then you feel what the impact of this one crime is, not just to families, but to an entire nation. So that's where it starts, right? Something happens that hurts people. And that hurts perhaps more than people. That also hurts a system that somehow guarantees that things will be just. Now, of course, let's say, if I immediately become a cynic or a skeptic, I will say, yeah, but most of the time legal systems have defended inequalities and injustice and violence and so forth. This is all true. And perhaps a little later in this conversation, we would have to talk about how my views on the legal system changed from the 70s up until now, if I can give away that clue. So now I think that the legal system might be precisely a last stronghold against extremely dangerous, both political and criminal organizations that want to avoid the rule of law. And let's say there have been times in which I would have seen the positive sides of that, but I start to see less and less of them. So in this case, let's say people hurt, a crime, a nation hurt. And then the question is, what can the law do? And it can only do so much. So there has already, let's say, a struggle been going on. So who is going to supervise this? Where is this going to be held and so forth? And then we get into probably a years-long process where we're going to try to find out whether we can find the people who did this. So that's the law part. Meanwhile, people still have their feelings and they're still hurt. And even if at some point, and we will have to see whether that happens, people will be convicted, the question is very much whether people will feel that they've been done justice. They will feel so in part, but there will always be something, I think, where they will think or feel it's not enough. And it's precisely there, I think, where art plays its role, in the sense that either it propels the question, the call for justice, or it comes in when a case is closed and it isn't, in terms of the things that people feel. So then art starts to deal with that. Might even mean that art comes in to say, wait a minute, the case is closed, but it was closed wrongly. So we have to kind of keep on kind of irritating the system. And most nasty part, there's also art that, let's say, might defend the Russian position, so to speak. It depends a bit on what you define as art, but there's loads of anecdotes, scenarios, might even be games at some point. I think so far, Pierre, the interesting thing with this case is that art is waiting, in a sense. It's waiting because it's too fresh. So we have this one big, let's say, work of art, let's say a monument, a memorial that is clearly there. But as you may feel, there's such an enormous amount of art to be made out of this, and it's not being done. And the reason, I think, is people are waiting. It's still too fresh and too precarious, and things are still kind of in the process of the legal system. But my expectation is that this case will propel many works of art.
Yeah, I did get the sense that you saw that art owes its living to a certain extent to the impossibility of obtaining justice as a kind of fait accompli, that this is something that is not guaranteed by legal systems at all. I want us to go into the broad theoretical frameworks that you outline. So you proposed a whole set of different ways of thinking about the logics of law and how they connect to the logics of justice, yeah, and how art might insert itself into all of them. And I guess these are classifications that are quite familiar from literary analysis. But how they connect to legal studies and how they connect to art, I think, requires a little bit of unpacking. So you introduced this idea of thirds, where you have these kind of triads, and I'm going to just propose a couple of them. So you propose a pairing of fear and desire, for instance, where the law is governed by fear, justice is represented by desire, whereas art in that particular triad is a mechanism that deals with apathy. Another one out of, I guess, 7 in the book is one that brings together reason, dreaming, and a hallucination. This struck me as an incredibly interesting way of dealing with all the things that art does, and also dealing with the different logics, the different ways in which law and justice represent themselves. So I think it was great because I think what you've done is great here because it takes art as the guiding force, even though this is not how you present it originally in the theoretical treatment.
I think you're spot on. I have no, let's say, patience with people who give art, let's say, the role of embodying the higher grounds, the higher moral grounds or the higher aesthetic grounds, what have you.
Well, you're not making friends in the art academy then, I'm afraid. Yeah.
So in my reading of things, art is all over the place.
Mm.
And if I make a sort of systematic analysis where I think, wait a minute, perhaps the system of law has its own forms of logic, and likewise the realm of justice has its own forms of logic.
Mm.
These two can be related productively. One could be, let's say, that the two affirm one another. So if we have, let's say, the logic of reason and the logic of dreams, then, for instance, if my dreams about justice are somehow answered by the reasonability of law, then the two affirm one another. They might also be able to disturb one another. If my dreams of justice, for instance, would imply that I want to be as rich as possible, and I don't want to be bothered by the fact that more than half of the population is suffering from this, then the law might affirm that in saying, yes, your private property is protected, or the law might disturb that when it says, wait a minute, this is excessive, and this is no longer answering to principles of social justice. So you'll have to give up some of your income, right? So that's the disturbance part and the affirmative part. This is all productive. So there is no way in which, let's say, disturbance could be avoided. Disturbance is productive, but it's something else than what I define as disruption. And the disruption works in both ways. So it can disrupt both the logic of reason and the logic of the dream. And this happens, for instance, and this is my argument in the final chapter, when you live in times of hallucination. Very practically, one of the manifestations of hallucination is the enormous amount of scenarios that's being produced by bots. And bots that are, again, in the service of certain powers. So, for instance, if, let's say, one of the major opponents of President Putin is murdered right in front of the Kremlin, which is an impressive thing to do, and about an hour or two later, there's already a diversity of different scenarios, of different possibilities, of different anecdotes circulating the internet, then it becomes a very difficult thing to still know what the dream of justice would be or the logic of reason of the system of law, because you get confused. And at some point, it doesn't matter anymore. And again, I would say art plays a role possibly in all these three realms. So it can defend the logic of reason. I mean, most essays do this. If you want to follow an essay, there's an argument being developed and someone wants to convince you, right? Logic of dreams, I mean, innumerable forms of art, literature, trying to come up with, okay, what would we desire, what would be just? And art can also be at the pivot of hallucinations. In a sense, the book tries to time and again see where are we and what kind of works am I looking at. So I can clearly confess that I didn't look too much at disruptive forms of art in this book. Because actually I think there's already enough of them, and it might be another book. And in a sense, let's say, my political or ethical agenda is pretty clear, I think, if once you've read it. I mean, you may have gotten some headaches because of the complexities, but my stance or the political stance that I take or the ethical stance that I take is pretty clear, I think. Or whose side am I on? Actually, one of the questions that this book poses is, time and again, ask yourself, whose side are you on? Because that determines the entire analysis of what you're looking at.
Just as an aside, maybe you could ask you to give an example or a definition of disruptive art, because that's something that I didn't really notice as being excluded here. Maybe we have very different readings of the functions of some of the practices, but let's do that and then maybe get into a first serious case study to try to figure out what non-disruptive art does.
So The final chapter ends with a film by Nicolas Refn called Only God Forgives. And that film has disturbed audiences, or confused audiences. It also confused me when I saw it for the first time. And it also grabbed me.
And so this is a 2013 work set in Bangkok in which a police officer named Chang pretty much takes the idea of justice in his own hands. This is set against a background of Thailand's quite brutal war on drugs, quite reminiscent, I guess, of what has been going on more recently in the Philippines. And we have this moral agent who both produces evidence and acts on it, and as the title suggests, well, waits for God to forgive, I guess.
Yeah. Yeah. Whereas partly he also takes that position of a god. So looking at that movie, I was puzzled by what is it doing? If I'm allowed to make a small detour here, so I've also studied, let's say, the work of Marquise de Sade. And one of the introductions that made me laugh was a French edition in which a very decent scholar, no doubt, philosopher, said that this is no pornography because it's philosophy. And
see, oh, this is brilliant. I mean, it's important. You need to know which section of the library to put the book on.
See, but you have to laugh as well, because this philosopher seemed to be missing the point. It is both. And this is also why it's disruptive. So in a sense, de Sade is also disrupting the very basis of ethical behavior. I can walk that route and saying yes, but that also helps us to think through what ethics means, of course. But it's also disruptive, and it is. And in this case, with this movie, I think it's very hard to draw some sort of moral lesson out of it or some sort of ethical stance. It's more about precisely the confusion that you don't know when looking at this movie what's real, what is a dream, or, and that's the disturbing part, what's a hallucination. And the dream, especially in relation, let's say, to the history of cinematography, can still be translated back. Let's say the classic example would be all the movies by Hitchcock. He studied Freud. So if you know the key, you can translate back what the images, in a sense, connote or what they mean. But in the case of this movie, there's images in it that don't seem to have a source in a subject or an actor in the movie, a character. Which means then that on a level of trying to distinguish what's referential, what's real, and what is unreal, the movie doesn't give an answer. And it's within this, let's say, fluidity of reality and hallucination that this character of Chang plays his role. And that's also why I do read the movie in an international context, where there's more and more violence internationally related both to quasi, let's say, official organizations, paramilitary organizations, organized crime, and political actors claiming that they will solve things or clean things up. But actually what's happening is that we get into a turbulence of hallucinatory situations and images in which it's no longer possible to assess what is true. And that's why I think this movie is disturbing, not in a sense that it kind of makes me incoherent, but it's disturbing in the fact that it can be brought back to one of these positions. And in that sense, I think the movie is bizarrely realistic, because if you take a good look around, there's loads of things like this happening.
Well, let's stick with this idea. So in the book, you use this case study of the film to discuss the habeas corpus as a principle and the threat, clearly manifest both in the kind of Thai or Philippine war on drug situations where executions just take place extrajudicially, but equally in jurisdictions which we would expect to be far more reliable. So the existence of a Guantanamo Bay extraordinary rendition, right, and so on. Yeah. Maybe you could speak a little bit about how you see the connection between what's happening in the film and and the reality of habeas corpus being under threat, and what it is that art does between the film and the reality. Like, what's the connection between the film and the Supreme Court of the United States?
Yeah. Perhaps another detour. One of my newest PhDs is going to look at the theme of civil war in the United States at the moment, which is an important theme and a growing industry even, which is not reflecting back on the civil war that was, but the civil war to come. And you'd be surprised what an immensity of literature, gaming, very different forms of art are kind of struggling with this theme or propelling it. If we have as a fact now that a president who has officially and legally been defeated simply said it was untrue, as a result of which a large part of his constituency, more than 60 or 70%, I believe, still believes that the sitting president of the United States is an illegal president, then, Pierre, we are precisely where I think this movie is hinting at. Then we are living in times of hallucination, because what this former president has been doing is producing his own reality. But it's an own reality that is translated to an entire populace for a part. And at that point, it becomes very difficult to still think about, let's say, the rule of law or regular ways of doing politics, because the very result of this hallucination might be that we end up in a civil war, which is already explored, visualized, imagined by very different forms of art. And these as well, then, are not reflecting on, let's say, a reality. They are rather proposing a situation that doesn't exist yet, could exist, or, strangely enough, then loops back on, let's say, what's currently going on. And that's then people saying, yes, actually, we are already in a civil war. So let's say the habeas corpus principle is so important. And that's also why I pay attention in that. That was difficult to do, actually. I pay attention to where does this start? So where does the habeas corpus principle start? It starts in a situation in the Middle Ages where there's simply no rule of law. And way up until the 16th century, let's say if you traveled through a certain country, one people ruling that area could simply hijack you or put you in jail or in a dungeon or what have you, and then ask your family or what have you to pay for your release. And this was then principal point of, can you take someone and take that person prisoner and put him in a dungeon? Or is there a power that can somehow say, wait a minute, you have to produce that body so that we can see it and that we can see what you've done with it? That's a very principal point. And that brings us in other problems, by the way, because then you could argue this is where the entire problem of sovereignty starts. Apparently, then we need to have some sort of supreme power, although I don't think that's necessarily the case. So I'm very much interested in the ICC, International Criminal Court in The Hague, which doesn't have a source in the United Nations. It is a bottom-up organization. That's also its weakness, by the way, but it's a bottom-up organization. So this is a voluntary organization where countries have to sign in, so to speak. And even if it's a fuzzy authority, it is somehow a threatening authority. It's not coincidental that neither the United States, nor Russia, nor China have committed themselves to this court, right? And in a sense, they are afraid of it, although it's a court that has no supreme authority, but it has some sort of authority. So the habeas corpus principle depends on the fact that some entity with some kind of authority can say, I want to see that body. Now, you already mentioned Guantanamo Bay. I think this is one of the crimes of the United States of the last decades. I mean, it's indefensible, legally speaking. This is also why Obama said, I'm going to abolish it, but he couldn't. But he knew, as a legal scholar, that this is indefensible. And the fact that happened, and that it somehow was accepted as normal, because there was no large international protest against this, also not politically speaking, to me, that's a sign of an hallucinatory reality. Going back to, let's say, art, there's art protesting against this. I don't know many forms of art who would defend this. And there's art that, in a sense, is fascinated by this hallucinatory middle. And you could also consider that not just in terms of disruption, but in terms of an investigation. So perhaps indeed, let's say, it would be very important if art brings people or more parts of the international audience to that moment at which you think, wait a minute, where am I? What is this? And then kind of come out of that and think, this is indefensible. But again, I didn't see it happen. So there is works of art on this issue. How effective is it? And then I think one of the questions to think through is, in what times are we living? So let's say if we live in a bourgeois society where the rule of law is functional, might be fun to get into works of art that are truly hallucinatory. Let's say parts of the avant-garde have tried that.
Yeah.
But if you live in hallucinatory times, then let's say making hallucinatory art might simply be mimicking the situation without, let's say, having any edge to it.
Well, let's try to loop back maybe to one of the earlier chapters where some more positive things are happening. And you open your serious consideration of your case studies with the logics of fear and desire.
Yeah.
And your example at the beginning of the book is Milo Rao's The Congo Tribunal,
Mm-hmm.
which is a theatrical staging of a tribunal, of a court process from 2015. And it takes as its subject the plethora of abuses of all sorts of rights. But in absence of those kind of structures working, it is occasionally down to artists to try to bring together the logics of the law, the desires of the populace. So maybe you could describe a little bit what it is that the artist Milo Rao was able to do and how that plays out.
Once art starts to really intervene, if it can, then we are in the mess of politics. That's what it is. And the essence of politics is messy. So there is no purity in politics. And I think it is slightly not really fair to ask that art should be pure in its intervention in very complicated situations and ignore the fact that that's impossible. So yes, Milo Rao's work can be criticized for several reasons, but he also did something that is, I think, very important and very, very promising and also almost paradigmatic. Okay, so there's no rule of law. There's no art either, by the way, almost no art, because it's a chaos. It's anarchy, but functional anarchy. Time and again, especially in Eastern Congo, there are certain parties with interests that profit from this, that profit from the fact that the rule of law does not exist there. And what Milo Rao then does, I think, is fascinating, because he sets up a tribunal. There was also, let's say, a version in Berlin, but he wants it to be done there, right at the spot, with the actors that are engaged in the very complexity of what's going on. And it was successful, or it worked, because people wanted to participate, thinking this is only art. And I think that at least some of them were in for a surprise. Because the very fact that a tribunal, even if it was an official tribunal, was being shown, was being worked out with a real audience. Very important, I think. It's also part of this chapter. There is a theatrical origin to let's say, the very performance of a court case that needs a live audience. This is one of, let's say, the animal parts of human beings. We have to be there in the flesh, bodies looking at one another, sensing one another, smelling one another. That's actually what Milo Rao did. And I consider that to be a very worthwhile effort, because it gave people the idea it is possible. The law is not dead. Justice is not dead. It is possible to bring people to court. So now, again, we are some years later. The rule of law, of course, is not restored. Who would want to give that task to art? That it would be able to restore the rule of law. But that's not the point here. I think the point here is that it shows the possibility. I find that worthy of praise, so to speak, if only because, let's say, the people who did this also were themselves in very dangerous situations. So they were not afraid to go in there, so to speak. And then in this chapter, the logic of fear is defined as the rule of law's fear that there would be another law, let's say a plurality of laws. The logic of desire is that time and again people want there to be justice and also want there to be then a trustworthy system of law. And in this case, the thing that disrupts it is apathy, where people don't care anymore because they were traumatized too much or they're too tired or what have you, and then they don't care anymore whether it's a system of law or whether there's no justice, what have you. And actually, that's pretty much what the situation in the Eastern Congo is, that large parts of the populace are forced into a state of apathy.
Well, that's incredibly interesting. I've come across examples of quite similar sounding projects in many different contexts. I mean, this tribunal idea clearly performs a function that civil society is interested in. Not so long ago in London, a group of artists and activists staged a tribunal in which they put Brexit on trial. That's a trivial example, and I mean the flaw there was that no one who represented the pro-Brexit side was even present in the room. But there have been plenty of examples, quite often engineered by artists, and I was really taken in by your discussion of indeed the theatricality of the legal process. Mm-hmm. So I wonder if I could ask you to say a few more things, a little bit about the history of this theatricality, and one other thing that came to mind. Thinking about, again, in the Congo, the idea being not necessarily that we would want to make the law come to its senses and be performed, but rather think about the plurality of laws and changes in the law. Whether there's something to be said about the role of theatricality and the role of art in lawmaking.
Small detour, but perhaps no, that's not a detour. That's an essence as well. So one of my other PhDs wrote a book that was one big argument against animal rights. What does it mean that one species grants itself the right to give other animals rights? This comes back to, let's say, one of the major themes in my work, which is sovereignty, right? So apparently human beings grant themselves the supreme power to distribute rights, and most of the time to animals with two eyes that preferably can show expression, especially when they are in pain and so forth. The principal argument against this was that we don't have that. We cannot defend that position. And what the nice thing about this analysis was that it made me think, okay, suppose then that animal rights is not the way to go. What is? And that's when I wrote, together with another of my PhDs, an article about procedure. So we don't need, let's say, an analysis of animal rights. We need to ask who is to be the judge between human beings and animals. And we had this fascinating 10th century story, a big book even, written by the Pure Brethren of Basra, which was an Islamic center in Baghdad, where they wrote a book called The Case of the Animals Against Mankind. And they bring the case of the animals before the king of the jinn. So in Islam, you have three entities: animals, human beings, and it's a rather awkward translation, ghosts. The important point here is that the case of the animals is not brought before a human court. It's brought before an independent court. And I think this procedural point is way more important in terms of achieving justice than talking about rights. So first, the procedure has to be there, on the basis of which we can start to talk about, let's say, the establishment of justice. And that's also related to the argument that I'm making in this chapter. So first, we need to have a space where we can meet with a distribution of roles in front of one another, physically there, and where we can confront the things that have been done. And that's the theatrical origin. And precisely again with this third, so this is also why I go back to the origin of Greek theater, where you have, let's say, a storyteller first, and then comes in a second actor who answers. The Greek term is hypokrites, which we can still recognize in our hypocrite, right? So that's been, let's say, that has become, let's say, an equivalent of actor as someone who produces an illusionary reality, but that's not the point. The point is, first, hypokrites means he who answers. Then we have two speakers. But the great innovation is if we get three speakers, which is when the third speaker can come in between. And this is the theatrical origin. And I think you are very right in pointing out that this basic theatrical principle also translates itself to an audience, in the sense that if we are there as an audience, perhaps, let's say, in terms of procedure, we are not allowed to intervene, but we are there, and in a sense, we are intervening because we are watching, which makes all the people on stage aware that we are watching. And by the way, there are a few occasions in which the audience did intervene, but then, of course, the violence of the law, which is another chapter, starts to immediately raise its head. But again, the fact that the law is principally open to an audience is pivotal, because it holds this potential of an audience that either intervenes on the spot or that goes home and thinks, wait a minute, I'm not going to accept this. I will intervene in this process by different means then. So the animal reality of us being there together in the flesh is pivotal to law. This is also why I have my great doubts about the fact that mediation is a growing business in law. I mean, most of my legal friends are very fond of this, and I can understand why they're fond of it, and I even see, let's say, some advantages of it, but there's also a danger to it. If I have enough money, I can get away with anything.
I would question whether this is necessarily anything new, whether mediation is what has brought this.
No, but then it has a legal aura, right? So then...
Yeah, of course, yeah. But actually, what's the introduction of the third speaker, whether it's the audience or whether it's someone who brings in an extra, either a watchful eye or even brings in a little bit of testimony, brings us quite neatly to the chapter that I think interested me the most. And this is your consideration of the official versus the officious, which looks at ways in which, say, non-standard forms of evidence can become evidence. Things like testimony that doesn't necessarily meet the threshold of legal testimony or witness testimony can somehow become incorporated into legal processes. And we're looking here at essentially fiction. The Mexican US writer's Valeria Luiselli's book, The Lost Children Archive from 2019, I think, which is, well, a document, I guess, in a certain way, but it's also a complete fiction which looks at the reality of the deportation of children, migrant children, under the Obama administration, which is one of those beautiful moments, again, when the law is completely happy looking at itself in a mirror and doing things that we would probably all condemn as unethical. I'd like us to think a little bit about ways in which the idea of testimony and records and that kind of physical, but not always real presence is brought into these kind of situations that you consider here.
At some point, a couple of years ago, in the fair city of Amsterdam, students started to protest, and they occupied, let's say, the central office of the university. And the reason was that there were budget cuts again and so forth, and the university had also been investing money in the wrong places, so to speak. So in a sense, the budget cuts were caused by the fact that the university had played with money. And one of the key icons of that battle was a building in the center of Amsterdam that was a university building that had been sold to a hotel. So they've occupied, let's say, the central building, and I'm asked to do a presentation. And I was annoying.
So this word keeps on coming back.
Because I'd been fighting for a school actually in the center of Utrecht for 5 years as an activist. And the project that we stopped after these 5 years was a 50 million euro project. We got to know the ins and outs of Dutch society. We encountered organized crime, but we researched everything. And we found out that this simple school was part of an entire circus of about 40 different schools in Utrecht, who all had to be sold so that a big chunk of education for adolescents could reorganize itself in 3 central buildings. But there was way more money to be made, of course, than simply what these organizations needed to make these new buildings. I mean, all these schools could be turned, for instance, into apartments, which is where real estate developers were interested. Millions involved. And we traced it. We traced everything, which took a lot of time and a lot of effort and a lot of perseverance and annoying people. But I told the students in Amsterdam, okay, so let's say this building that you're not kind of talking a lot about is the icon. For how much money has it been sold to whom? And what is it connected to? And they looked at me with rabbit eyes and they said, we don't know. And then I said, then we can stop talking, because then this is not serious. You don't know what the forces are that are connected to what you say is the problem. So you haven't traced the money, you haven't followed the money, and you haven't documented it. And that is, I think, part of the argument in this chapter. If the law works by means of what is official, then you have to counterbalance that from the realm of justice by developing your own documentation. That's what I admire about these two books by Luiselli. This is actually what she describes, right? So the trick that the Obama administration played was not that they changed the law, but where previously very young children, let's say between 4 and 12, came to the States would have a year to find legal support, they now changed that. They wanted to give them priority. That's the nice phrase of it, right? Which meant that they had 2 weeks. And of course, let's say, the idea behind this was that they could be expelled after 2 weeks. So what the people who wanted to work against this or defend the children had to do was use these 2 weeks to find information, to counter document. And this is then what I call officious, also because of the etymology of the term. So often people know what's officially the case and what is officious, right? So there's something going on that we know is true, but it's not official. There's also an element to officious, again, that's annoying or disturbing or it's perseverant. And that's what I liked about it. So I refused to use the term informal because precisely it has to have form, which need not be paper, by the way. So this is also why I give the example at the beginning of that chapter of Australia, where, and I think, for instance, what's happening in Canada right now, it's chilling. It's chilling.
We're talking about the forced child separations in Australia in the 20th century and in Canada until shockingly recently, just being uncovered.
Yeah. So often this was not documented, but there were people telling stories about it. And I'm pretty sure now that this has come out in the open, that people will start to look for the narratives, the stories, and that there are people who will be able to tell stories, even if there are no documents.
Yeah.
So it's not about, let's say, making archives. It might also be, I'm telling this story and I'm telling it again, and I'm telling it to you, and I may tell it, let's say, in secrecy first, but I'm telling it. And then we have something. So let's say the horror of the stories that Luiselli is dealing with is, in a sense, best captured by the children in the desert, who simply disappear because the sun eats them up, right? There's nothing that can bring them, in a sense, back to life. And this is why I admire the fictional work. So one work that I'm looking at is an essay where Luiselli describes the questions that they used to get the information from the children that could lead to a legal case. So how can you bring people back to life of which nothing is left in the desert? By writing fiction. And that's also, I would call, an officious way of dealing with them, of bringing them back to life in a restricted way, of course. But I think in terms of activism, this is one of the more underestimated things to look at. I think in the current circumstances, protesting is dead. We've been protesting so much and with such big numbers, nothing has changed. In the Netherlands, a very famous case now is the Urgenda case, or the case against Shell. And in both cases, they've won. And these are important cases about ecological issues, but based on large amounts of documentation, not made by official organizations, but by citizens, by people coming together and coming up with their own documentation.
Yeah, this is fascinating, and actually takes us very close to the heart of my own research, which looks at the ways in which knowing one's enemy's business and procedures might actually be a very good route towards winning one's case. And the law is clearly one such example where it's difficult to imagine a better way of getting what one wants than actually playing the game. That conversation of the question of what art does in this circumstances, I think remains quite moot. And I wonder if I could a very selfish way, draw you into a deeper conversation about forensic architecture. This is a practice that I have a particular interest in. And just to introduce it briefly, forensic architecture are an investigative agency that have since 2010 been cited at Goldsmiths College in London, founded by architect and activist I.L. Wiseman. And they do all sorts of investigations, quite heavy duty investigations of usually human rights breaches, but also environmental crimes and so on and so on. And they do it with techniques like open source intelligence. They do it with photogrammetry. They do it with modeling, quite sophisticated and usually, let's say, expensive or resource intensive investigations. They've done it maybe 70 times. And recently, there's finally come a point at where a piece of evidence that they've produced has convinced the court, or rather has been part of the body of evidence that has convinced the court. So one of the questions that keeps on popping up around forensic architecture, which I think is a little bit reductive, but actually incredibly important, is whether what they do still counts as art when the attempted fiction is not even alluded to. Forensic architecture more often than not outright dismiss the notion of them being artists. That doesn't stop them from being exhibited in all sorts of galleries and being nominated for the Turner Prize and so on. What is the role of an artistic practice like this? What do they do? If what they do is essentially present legal files in the public realm, is this still an artistic endeavor? It's very difficult to really pose this as a more sophisticated question, but it's strikes me as this is possibly a counterpoint to quite a few of your case studies, precisely because it's so complicated and doesn't really come with any good answers, and because it plays all the games at the same time.
Mm-hmm. Okay. I think it's a very relevant question and a good question, or an important issue. The easy way out would be to say, yes, but since the 20th century, the very idea of art has become so broad that anything is art. But then I would go against my own argument that I like sharp definitions, right? So if taking my bike to the station also becomes art, and conceptually speaking, I could make that argument, then perhaps too much is becoming art. I think one of the pivots, which is also, I think, why Basis Actuele Kunst, this is the art center in Utrecht, BAC, was interested in this, is creating a forum. Now, how do you create a forum? Which would be a place which is partly theatrical, where we can come together to talk about things, right? So I think one of the issues of forensic architecture is not to prove something or to prove that others are wrong. It's to open up a conversation, a debate about something that has been silenced or that has been taking place behind the scenes. In a sense, then, I would say forensic architecture is deeply theatrical in its modus operandi, in the sense that it wants to say, this happened in the corridors, and now we're going to bring it to a stage, as a result of which that we can all look at it again. So one of the let's say the things that I admired was the work they did on the NSU in Germany, where, let's say, there was a possibility of the NSU, 3 people underground killing not original Germans secretly at some point at a place where someone of the secret services was present. So they lay out the ground floor of that space. And what does that do to me as an audience? So I'm not looking at a restaging of what happened, which would perhaps be too easy. No, I have the space, I have the ground floor, I can check the steps. So in a sense, they ask me to co-invest or to co-investigate. So one aspect then is this forum part. How do we create a theatrical situation again in which we can participate, in which things are being brought out into the open and we are able to say what we think about it? That would be one thing. The other thing is, I think Weizmann is pretty explicit You might be right in saying if it becomes simply a bureau of investigation, then in a sense art will be dead. That's true. But it's not if you say we are not a bureau of investigation. We are trying to find out possible narratives. And I think, say, in terms of looking at this critically, this would be a pain point, right? So the things that I've seen from them often are not that open in the sense that you could say, yes, perhaps that happened, perhaps something else as well. So there seems to be, there is often an aura that they seem to claim we have found out that this is actually the case. And that would go against their argument that we need imaginations, alternatives, the opening up of cases. But even then, I would not argue that it's not art. It might be bad art, actually, in the sense that
I can't possibly comment on the record because my PhD might rely on my position, but that has been said.
Yeah.
I think what I'm drawn to out of our conversation is to try to think a little bit about the aesthetic element, not just in this particular practice, but like the ideas of evidentiary aesthetics and rhetorical aesthetics, which is the one way with which art can easily defend itself. And I think it would be quite easy to read the case studies in your book and to actually see that the aesthetic is incredibly important to how all of these works of art play the role that they do.
Yeah.
That's not necessarily to say that the same role couldn't have been played by other processes. I presume, I'm not a legal scholar, so I may be completely wrong, but I presume that in some kind of crystallized, idealized abstraction of the law is already performing justice. So in that situation where the law and morality come together, there's no need for art to mediate anything. But since we're not living in this perfect world, I guess we do need to rely on art, which is both a kind of exciting but also a very bleak state of affairs, I guess.
I'm not sure whether it's a bleak state of affairs. And going back to your previous remark, so if you would have, let's say, the coincidence of law doing its perfect work, which, by the way, would be impossible because the realm of justice is disparate. And this, I think, is also part of the fascinating work by Peter Goodrich, needs its own aesthetics. It needs its own imagery, its own clothes. So there's also an aesthetic element to the very performance of art, without which it wouldn't be much, or it wouldn't have that force. And I think the enormous power in aesthetics, I would define that on the basis of a distinction that I also introduce in the first chapter that Spinoza made between potestas and potentia. Potestas being the power from above, and potentia being the infinite potential in everything that exists. So what potestas time and again tries is to rule that immensity, and it can't. It can only kind of be some sort of parasite on it, although it can be a very powerful parasite. And these two involve different forms of aesthetics, I would argue. So power also needs its aesthetics. That's been studied a lot. For instance, it's also part of what Walter Benjamin analyzes. So Nazism had its aesthetics, and a very powerful one. So in a different book, perhaps you could argue we would have to define more sharply what kind of aesthetics are we talking about. Is this the aesthetics of power or the aesthetics of the potential? And sometimes the two can be used both ways, but at points they also diverge. And then it's impossible to use the one aesthetics in the other context and the other way around. But in terms of what I've been trying to argue for in this book, I think the force of art is aesthetic in the sense that it stays with us. So if I have an argument, I can convince you, or you can start to doubt, or what have you. But the beauty, and not in the beautiful sense, but the beauty of art and aesthetics is that it hits us on so many levels. And somehow it travels with us. It doesn't disappear. So in terms of justice, I would always put my cards on art because of this very potential. That if it's a successful piece of art, it will travel with us and it will survive decades and at times hundreds of years.
Well, that's a beautiful tribute to your subject. Thank you. Thank you so much for your time and your generous sharing of your work with us. But before I let you go, I want to ask you about your future research. You signed up to write about 7 books in the course of our conversation now. But where do you see yourself going next? And will you follow up on any of this research?
I surely will. We just got a big project funded by the National Dutch Society of Sciences, which is about playing politics. And this is together with 4 colleagues from the Department of Media Studies, Philosophy, Literature. And what we're looking at is the ways in which certain contemporary politicians, but there's a lot of them by now, seem to be playing a political game that doesn't answer to the logic of the way in which we have been playing politics. Now, what does that mean? Does it mean that we have to analyze what this play with the former play is, or this play with the former game? Or do we have to rethink what politics is about and how it should be played or can be played? So this is clearly about, let's say, populism, in the sense that what it is playing with. And I'll be looking then at the ways in which populist politicians have been trying to play with the law. So there's several cases by now, and the fascinating thing is, as long as the law supports them or guarantees their safety, it's good. And as soon as they're criticized, they drop the law as if it's a cup of coffee, and they're not bothered by spilling it. So I'll be looking at the ways in which they are playing with the feel for law, which is, my argument would be that that's carried by the larger population, that you still feel what the law should be. And if we start to play with that, we might be ending up in very dangerous situations. Or not. That's what I'm going to look at. So that's one part. And then I've been doing classes in The Hague for international studies called Culture Interaction. And something new now is urban studies, where I did Imagining the City. And that's very much related again to, let's say, issues of justice in urban environments. I'll keep that, let's say, in mind, but I'm working now on a book with a young colleague of mine that would be about culture interactions based on this idea of potestas potentia, and then also bringing in the different cultures that we now, so let's say, classically speaking, 19th century, 20th century culture interactions is about human beings interacting, but I also involve animals and technologies then, that we are ending up in a very more complex field of cultural interactions and how we can think about that and deal with that. Which in each chapter starts with music, by the way. That's also something that we didn't discuss yet. Yeah.
Ah, brilliant.
Yeah.
Well, I look forward to hearing you back on the New Books Network. Frans-Willem, thank you so much.
And thank you, Pierre, for having me. It was a joy speaking to you. So.
Art as an Interface of Law and Justice, Affirmation, Disturbance, Disruption by Frans-Willem Korsten is published by Heart. I'm Pierre Delancey, and the editor is Marshall Poe. Thank you for listening, and join us next time.